Welcome to Susquehanna Legal Services video workshop on landlord-tenant law. In this video you will see a typical district justice hearing. Although the facts involve a landlord-tenant dispute, the video should be useful to anyone who has a civil case in front of a district justice. We're fortunate to have with us today 3 district justices who will participate in a short panel discussion after the video to highlight for you the main points you should remember as your hearing date approaches. Now let's watch District Justice Leo Armbruster as he conducts a landlord-tenant hearing which could occur in almost any district justice court in the Commonwealth.
I'll call this hearing to order. It's the date and time set aside for a landlord-tenant action, docket number LT 29 of 1995, William Jones versus James and Mary Smith. It's an action filed by a landlord asking for rent in the amount of $750, late charges in the amount of $430, and damages in the amount of $50, totaling a claim exclusive of costs in the amount of $1,230. It is March 26, 1995, 10:30 a.m. Mr. Jones, are you ready to proceed in your case? Are there any amendments to make to your complaint?
No, sir.
Let me tell you about how this proceeding is going to take place. Since neither of you are represented by attorneys, I'll be a little more lax with the rules of procedure. However, what I will not allow is this to degenerate into a conversation or an argument between the parties. I will first ask the landlord to put on his case. He will produce any documents and witnesses that he may have. And then the defendant will have a chance to question the landlord about the things that he has just said. And after he is done with his case, which is called resting his case, then the tenant can put on the reverse case, put on the opponent's case. I will not tolerate arguing, and I will not allow this to get out of hand. Is the plaintiff ready to proceed then at this time?
Yes, sir.
You may call your first witness or take the stand in your own behalf. Mr. Jones, I'd like you to raise your right hand, please. Do you swear or affirm under penalty of perjury that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Jones, now that you're under oath, you can present whatever testimony you have regarding this case and introduce any documentary evidence that you might have. Mr. Jones, one additional piece of advice is that as the plaintiff, you bear the burden of proving your complaint by competent evidence, and that burden does not shift unless the defendant puts on a case and asserts a point that she wants to make. Then she has to prove her case by a preponderance of competent evidence. Okay?
Thank you. Your Honor, I entered into a lease with James and Mary Smith on August 1st of last year for a rented property that I own on 123 South 4th Street in Lewisburg. At that time, her husband was living with her, and I don't know where he is now, but all I know is right now I am due rent for February and March in its entirety, and I'm going to receive half the rent of $125 for December and $125 for January. The original rent was for $250 a month, payable by the 3rd of the month, and a $5 a day late charge thereafter. What I want is I want my money, and I'd like to evict her if possible. I have here a copy of the lease agreement that she and her husband signed. I also have my rent receipts. I have also a bill for $50 for a broken window that occurred when her son was playing football in the backyard and they kicked the ball and broke the glass. And I have a witness to testify that this did occur. Your Honor, I served Mary an eviction notice on February 28th, and I have a copy of that with me. And I don't know what's happening in her life or what. All I know is that I want my money, and I haven't received payment. And I'd like to have her family move out, and I'd like to be able to rent the apartment because right now I can't make my mortgage payments. I'm out the money, and I need it.
Do you want her out? Do you want them out? Or do you, will you allow them to stay if all the rent in arrears is paid plus the costs?
Your Honor, I would like her evicted because she's not consistent with her payments. Also, in violation of the lease, there has been a small dog in the apartment, and the damage that's occurred to my property.
You're talking about the window now,
Yes.
the broken window. Do you have any further testimony?
No, sir.
Okay, verbal responses are always welcome in this court. You have no further testimony? Okay. You can submit then, at this time, any documents that you have. Do you have copies for the defendant that she may refer to as I review the documents?
Yes, sir.
Okay, please hand your copies to the defendant and then bring the originals up to me. Has the defendant had enough time to look over those documents?
Yes, Your Honor, I
Do you
have.
find anything wrong with them or inaccurate?
No, Your Honor.
Do you have any objection to them?
No.
Okay, I will accept them provisionally into the record subject to closer scrutiny before I make my decision. Do you have any questions to ask the plaintiff about what he's just testified to?
Just one, Your Honor. Just want to ask him if he would confirm that I did pay him a security deposit.
Yes, she did.
In what amount?
$250.
Any additional questions?
That's all.
Mr. Jones, do you have any additional witnesses?
Yes, I do, Your Honor.
And
I have
who might that be?
my neighbor, Sandy Miller, is here to testify for me about the broken window.
You may call her.
Sandy?
Please state your name and your address.
Sandy Miller, 127 South 4th Street, Lewisburg.
Okay, the plaintiff will now direct the questioning.
Sandy, do you live next door to my rented property?
Yes, I do.
Now, on February 27th, didn't you see Mary's kids out playing with a football in the backyard?
Mr. Jones, I'm going to have to interrupt you. That's what is called a leading question. You cannot testify for her. You can ask her what she remembers about the day. You can remind her of the day. You may not remind her of what she saw.
Oh. I'm sorry.
So you can frame your question accordingly.
Sandy, what did you see on February 27th?
Okay, I was standing at my kitchen sink and looking out my window, which faces the Smith's yard, and I saw Tommy and his brother tossing and kicking a football back and forth, and they had a little dog with them. Well, next thing I knew, I saw the football hit the storm door, and I heard the cracking noise of the glass, and right after that happened, the two boys and the dog went in the house. Then later that day, I went outside and I saw glass laying all over the ground over at the Smith's house.
Do you have any further testimony?
No.
Do you have any additional questions of this witness?
You did see a dog.
Yes, I saw a little black and white dog.
Thank you.
Does the defendant have any questions of this witness?
Yes, Your Honor, I have a couple of questions. Ms. Miller, do you like my kids?
Well, they can be annoying sometimes with their loud yelling and then with the dog barking.
And did you ever see a dog at our rental property before or after that date of the 27th?
No, I didn't.
You don't have any memory of seeing a dog there at any other time?
No, I only saw the dog on that day.
Thanks.
So when you say you were annoyed by the kids and the noise of the dog, you're talking about the noise of the dog on that one particular day.
Yes.
But the kids have annoyed you on other days.
Yes.
Mr. Jones, before I excuse your witness, do you have any additional questions you'd like to ask her?
No, I do not.
Miss Miller, you can step down then. Thank you for your testimony. I'm assuming that the plaintiff has rested his case. Is that correct?
Yes, Your Honor.
It's now time then to hear the defendant's case. Are you ready to proceed?
Yes, Your Honor, I am.
I will have to swear you in. Please raise your right hand. Do you swear or affirm under penalty of perjury that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and then state, to the best of your recollection, everything you can remember about this transaction.
Well, basically, a lot of the information is accurate and true, but I have some additions to the circumstances.
Well, it's my understanding you filed a counter-complaint?
That's right, Your Honor.
And what is that for?
That's in regard to the expenses I incurred for having to buy a space heater and also for the increase in my electric bill, which I have incurred because the landlord's failure to have the furnace repaired. And I think also the fact that he was given a security deposit by me is adequate money to go towards the repair of that furnace.
Okay. Well, how many days was the furnace out of commission? When did you first notice this?
It started in December.
And so how long were you without heat?
No, I'm sorry, Your Honor. It was January, from January 15th on until the present time.
You're still using the space heater?
Yes, sir.
And you have one space heater for the whole apartment?
One that I purchased and one that I've borrowed from a friend.
Where do you keep the space heater? Do you move it around the house?
Yes, we use it in the living room during the day, and I heat the children's bedroom with it at night.
And you have no heat?
And the other one I moved to my bedroom.
Mrs. Smith, just for informational purposes, because this is the first time I'm looking at the lease, the apartment it was a 1/2 double with 3 bedrooms. Is that correct?
2 bedrooms, Your Honor. Living room, a kitchen, and bath.
Okay. And it's my understanding you paid rent for December and half of January. Is that correct?
I paid half in December and half in January. The circumstances were mentioned earlier that my husband left in November. I've tried to demonstrate good faith in presenting what money that I had available each of those times. Since my husband left, I have applied for assistance. They haven't located him to attach his wages, so I have been waiting for my benefits to come through. And the money that I have had in the meantime, I've had to provide for my children with and provide for the heat in the household. So with the expense that I incurred, with the increase in my electric bill and the increase for having to pay for a space heater, and having lost my job in December, I feel that I've really tried to demonstrate good faith towards Mr. Jones, and in each of those circumstances, at least half each month. Since I am one of 2 signees on that lease agreement, I sort of felt as though I was doing what I could.
Another question comes to mind. Did you let your landlord know that the furnace was defective? And when did you do this?
I started noticing problems with the heat on the 15th of January, and I notified the landlord right away, and then several times thereafter. It was up to me to provide heat because nothing ever came of the phone calls or the contacts that I made. I think at one time he finally said, well, you can just go ahead and call someone since you haven't paid me the rent. You call someone and have them come in. I did do that, and I have brought him here to testify today about the estimate for the repairs, which I have.
And how much are those repairs?
His estimation was $300 for parts and labor.
Do you have a copy of that receipt for
Yes,
the plaintiff?
Your Honor, I do.
Okay. At the appropriate time, then I'll ask you to give a copy to the plaintiff.
Okay. I guess there's a couple other things I wanted to mention. As far as Mr. Jones wanting to evict me because of having a dog, it's really, it's inaccurate, Your Honor. I had kept that dog for one day for my mother while she was hospitalized. And even Miss Miller said that she's never seen that dog there before. And I should have had my mother come and testify that that black and white Boston Terrier is hers and belongs to her and resides with her. But I really didn't think that the dog being there that one day was going to become a focus of my eviction. So I haven't broken my agreement with the landlord by having a pet. I had a one-day stopover for a favor. And as far as the broken window, I'm not denying that my sons did break it, but I noticed and the furnace man can testify that there are a number of broken windows on the property that have never been repaired, as well as the furnace. So I also wanted to say that I feel that the late charges that I'm being assessed are really, they're ridiculous.
Regarding the electric bill, do you have your paid receipts? Have you paid the electric bills, or are they still outstanding?
They are paid, Your Honor, and I do have the receipts with me.
And I assume you will have a copy of the bills for the plaintiff.
Yes, Your Honor.
To my calculation, there are 86 days of late fees. Is that correct, Mr. Plaintiff?
Yes, I'm charging a late fee because I have to pay my mortgage, and the bank charges me for late payments, so I'm trying to recoup my expenses.
Mrs. Smith, at this time you can present any bills or estimates or receipts that you have to both myself and the plaintiff. Again, in regards to this batch of documentary evidence, I will consider them provisionally and subject to closer scrutiny later on in the proceeding. Is there any objection from the plaintiff regarding this evidence?
No, I do not.
Okay, thank you. Does the defendant have additional witnesses?
No, Your Honor, just Mr. Bruno. Mr. Bruno?
Mr. Bruno, raise your right hand. Do you swear or affirm under penalty of perjury that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Bruno, have you ever been in court before?
No, I haven't.
I see that you're a little bit nervous. What I'd like you to do is just relax, answer the questions that are put to you as truthfully as you can, and don't worry, everybody's a little bit nervous the first time in court. Mr. Bruno, please state for the record your name, your business name, and your address.
My name's Scott Bruno, and I'm the owner of Bruno Plumbing and Heating, and the business is located in RD4 Selinsgrove, Pennsylvania.
How long have you been in this business?
25 years.
Mrs. Smith, you can direct the questioning of your witness.
Mr. Bruno, do you remember coming to the apartment at 123 South 4th Street on the 23rd of January?
Yes, I do.
Would you tell the court about what you found to be the trouble with the heating system there?
Okay, I found that the burner unit on the furnace was bad and needed replaced, and it was worn out past repair, so I recommend it be replaced.
And did you subsequently inform the landlord that was the case?
I called the landlord, and he refused to pay the bill and said that you needed to pay it unless you moved out, and then he would take over the bill. So I haven't done any, I refuse to do any of the work until I know for sure I'm getting paid.
Mm-hmm. So, to the best of your knowledge, the heat is still not being supplied to the household?
Right. It wouldn't run at all, so until that's repaired, the furnace doesn't operate.
Well, you're saying definitely when you spoke with the landlord, he knew what the extent of the damages was, he knew what the estimated cost was, and he said he would not authorize the repair.
Yes, he said as long as you're living there that he won't pay for it, and he knew I gave him the amount over the phone, so he knows how much it was going to cost for the repairs. And he said if you wanted to pay for it, and that to go ahead and fix it, but I need to know for sure somebody's going to pay for it before I do any work.
Mm-hmm. I have no further questions, Your Honor.
Okay, I think I've heard enough on that point. Mr. Jones, do you have any questions to ask the defense witness at this time?
Mr. Bruno, didn't I authorize you to go ahead and do the work on that furnace?
Yes, you did, but she didn't have the money. I didn't know who was going to pay me until I know for sure I'm going to get paid. I refused to do any work on it.
Mr. Jones, any further questions?
No, Your Honor.
Okay, you may step down.
Thank you.
Mrs. Smith, do you rest your case?
Yes, I do, Your Honor.
Mr. Jones, now that the defense has presented her case, has her testimony brought to mind any testimony that you'd like to give on rebuttal?
No, I think I've said enough.
At this time, it appears that all the evidence has been submitted, and what I'll do is I'll take about a 10-minute break here to look over the documentation and to reconsider some of my notes and so on, and we'll meet back here in 10 minutes, and I'll announce the decision at that time. And we'll take a short break. We're back on the record, and I'm now ready to announce the decision. There's so much math involved in this case that I've taken the liberty to prepare a written opinion, which is the exception and not the rule. I must add that I probably would receive phone calls on the calculation if I didn't issue such an opinion. First, we'll deal with the issue of possession. The court awards possession to the plaintiff, Mr. Jones. Accordingly, Mrs. Smith, you must quit and take with you all your belongings or appeal the judgment for possession to the Court of Common Pleas of this county within the time allowed by law. If you do not leave the premises or appeal the judgment for possession, then Mr. Jones may return to this court and request what is called an order for possession, which would order the sheriff or a constable to begin evicting you. Next, we turn to the second issue of this case, the plaintiff's request for monetary damages. This court awards judgment to the plaintiff, Mr. Jones, for a portion of the rent claimed, which was initially $750. The court is deducting 25%, or $187.50 from that claim as a penalty upon the landlord for his lack of due diligence in getting the furnace repaired in the dead of winter. Thus, $562.50 in rent is awarded to Mr. Jones because, after all, Mrs. Smith did enjoy the use of the premises, which, aside from the problem of the furnace, was a fit place for human habitation. I am also awarding $50 for the repair of the window broken by the defendant's child. Thus, the plaintiff is awarded a gross judgment of $691, which includes $78.50 in filing fees paid by the plaintiff to get his case before the court. The court does reject Mr. Jones's claim for late fees on the rent because of the plaintiff's aforementioned lack of due diligence concerning the furnace repair. We now turn to Mrs. Smith's counter-complaint. The court will grant to the defendant an offset of $50 for the cost of a space heater and will award a portion of the electric bill she paid. She initially claimed $250 in electric bills, but she brought with her today receipts totaling $113, and this is all we can allow. Thus, the defendant is awarded $163 in damages, and if we add her $250 security deposit, she is allowed an offset of $413. Deducting the $413 offset from the plaintiff's gross award of $691, the plaintiff, Mr. Jones, is awarded a net judgment of $278. The monetary judgment must be paid directly to the plaintiff and not the court, no later than the time allowed for appeal to the Court of Common Pleas. If the money judgment has not been appealed by either party or the defendant has not made payment to the plaintiff, then the plaintiff may return to this court and file what is called an order of execution, which would direct the sheriff or a constable to levy against the movable, tangible property of the defendant. Another option is for the plaintiff to request from me a certified copy of the judgment, which he may then in turn file with the county prothonotary as a lien against the defendant, and that lien could be against real estate as well as tangible, movable property. Mrs. Smith, if you can't afford to pay this judgment in one installment, I can give you up to a year to pay it in 12 monthly installments. You can see me about that later. Mr. Jones, as the plaintiff, you have won a judgment, but it's up to you to decide how to act upon that judgment if Mrs. Smith does not follow through. If you let her hold over too long, you may have to file a new action for possession. You must act promptly on both your claim for monetary damages and the claim for possession. Now, does either party have any questions? If not, then this hearing is adjourned.
Welcome to the discussion portion of our video. My name is Pete Mackey. I'm the managing attorney of the Sunbury office of Susquehanna Legal Services. And with us on the panel today are District Justice Leo Armbruster of Union County, who was the judge in our hearing, Linda Balmick from Sullivan County, and Bill Kerr from Northumberland County. All these district justices bring a wealth of experience to our discussion today, and first question I'd like to ask is, of all the panel members, what are some of the most important do's and don'ts for parties appearing in front of you? Bill, do you want to take that one first?
Peter, what I think is that all litigants, whether they be the defendants or the landlords, should first of all remain calm and collected and treat all the parties in the proceeding with courtesy and respect. Okay. And not let it get down to the point where they're hollering back and forth at each other.
Okay. Linda?
In addition to that, they should also bring any documents with them to help prove their case, like any rent receipts that they have received from the landlord if they're the tenant, any outstanding bills for repairs if they're the landlord, anything like that. They must have documented for us to believe.
Does anyone ever bring copies like we saw in the hearing today?
For all parties?
Yes.
Not in my court.
Would you like to see that?
It would be nice, but it's not necessary.
Okay. Leo?
I think one of the things that has to be avoided in landlord-tenant hearings, there have been times in my court where the defendant has brought relatives along, and they sit in the courtroom listening to the testimony, and every once in a while you hear a gasp or a person will cry, "He's lying, he's lying." You should avoid, sort of coach your relatives not to participate in the proceeding.
Okay.
And I think Bill is correct in saying that the thing should not degenerate into an argument between the parties.
One thing which has always been interesting to me is unreasonable expectations that people have when they come into my office for an interview. They have certain ideas about the landlord-tenant process, and part of my job is to try to make sure that they understand what their rights are and their responsibilities. Have you seen in your courtrooms some examples of unreasonable expectations on the parts of either landlord or tenants. Linda, we'll go to you first on this one.
I think probably most of it is that most of the defendants that you see in there, the tenants, are so poor. They don't have the money. They've got kids. They're trying to feed them. And they say, you can't throw me out. I've got no place else to go.
And yet the law certainly...
And the law says that we can and we should. So it's a hard decision, but it's for the tenant to believe that you can't do it because of their lack of funds is unreasonable.
Okay. Leo, do you have any thoughts on that issue?
Yeah, as far as plaintiffs are concerned, one of my biggest frustrations is that some landlords, lessors, consider our courts to be a collection agency for them, and that by merely walking in and asserting a cause of action, they should automatically recover for everything they want. They want to get the person out, they want to get any monies that are due to them, which certainly is reasonable. However, they don't often do a lot of homework on how to prove their case.
And they often do not come prepared to present that case. They do not have the documentation that they need. They don't have the witnesses that they would need, and they expect that the courts will give them a free ride. And this is where the defendants should be prepared to examine this evidence that the landlords are presenting against them and assert their own defenses to this. Bring out that the landlord does not have any real proof to what he is claiming here today. And that goes to probably one of the most important issues, which is the notice to quit, that the landlord is required to give a tenant prior to beginning the eviction proceedings and the filing of the landlord-tenant complaint.
That is an absolute necessary element in the landlord-tenant action, and the landlord cannot get a judgment for possession of the property unless he or she has proven to the district justice that the notice given was proper under the law. Now, at this point, the legislature is considering changing the Landlord-Tenant Act and the rules which would govern your hearings. So we don't want to discuss the specifics, but you should feel comfortable in asking the district justice at the hearing questions about the appeal period and actually questions about the hearing itself. That's a point that you made to me earlier, Bill, that you think it's important that people feel comfortable in asking questions if they're coming in without a lawyer.
Many times the people coming in for these cases do not understand the courtroom procedure, which is one of the main focuses of this tape that you've just seen. And if you still are not sure when you come in, please ask the district justice as soon as you would have the opportunity in the courtroom to explain the procedure to you. And as District Justice Armbruster did so well in the tape, he went right through the whole process and explained it to all the people prior to the beginning of the proceeding.
You have anything to add on that point, folks?
Yeah, I did. You go first.
Well, I was just thinking, quite often when you ask the one party or the other if they have any questions to ask of the party that just testified, and quite often instead of asking questions, they'll go into a rebuttal, an argument, wanting to testify themselves at that point, and you just have to make them understand that this is where they ask questions, that they're not there to testify or rebut.
I think that since the focus of this tape is to help people, both landlords and tenants, represent themselves without attorneys, you'll notice that as I presided over the case, I was a little more activist in participating and asking questions than I would if both parties were represented by counsel. I'm basically mute when both parties are represented by counsel. Let the attorneys do the job and just rule on legal objections. But when I have two parties who are not real keen on legal procedure, I'll jump in for both of them because I want to get the whole picture. Now, some judges do and some don't.
But one of the advantages of doing that is you get to probably focus the parties a little bit better. They're not sure where they're going, and you know where they should be going to keep the thing going smoothly, so you have to kind of take control a little bit.
Well, if it's a tenancy of long duration, say a couple of years, there may have been many encounters between the parties and some emotions that run pretty deep between both parties. And they'll try to bring up things that happened 2 or 3 years ago that are not germane to the issue at hand, and that's what you have to try to filter out.
I would think that people who aren't lawyers and who haven't appeared in court before are probably nervous and unsure of themselves, don't understand cross-examination, don't understand hearsay, don't understand the procedure. What advice would you have for them coming into your courtroom for the first time?
Relax and be natural. If you have a question, ask it. If it's not going to be allowed, you'll be informed.
The district justices know that most people coming into their courtroom are not trained in the law and shouldn't really be expected to know the rules. And therefore, I think most district justices will try to help the person. They want to get the complete story out in the most efficient way, and they're not there to make people feel uncomfortable.
But at the same time, they still have to abide by the rules of evidence regarding hearsay testimony, and the most well-used piece of advice that I can give people who come into our court is always bring with you the people that you need to prove the points that you want to show. Bring them with you. Bring good documentation. Having a real person there to testify is always better than trying to put a piece of paper with supposedly their statement into evidence. It just will not work that way. Have the person there for you.
Well, we've developed in my court a set of directions that go out with both landlord-tenant and regular civil actions as to what's expected. And that includes bringing with you any documents, photographs, or live witnesses you need to prove certain points. So that they're well informed of that in advance. My clerks tell them when they file the case that if you have someone who's going to testify, have them there, because if they're not there, you can't get that testimony in.
And really, almost everything we've said today applies to all civil proceedings. There are, of course, specific rules and procedures for landlord-tenant cases, but they're really not much different from other civil cases. So we hope that this video will be helpful not only to landlords and tenants, but to other civil litigants. I want to thank the panel very much, and good luck to all of you.
Thank you, Pete.
Thank you.